Natalie, a second-year law student, has asked Professor Whitman to write her a letter of recommendation, and the professor initially agreed. However, after reviewing Natalie's materials, Professor Whitman called her in to make a suggestion.
Hello, Natalie.
Hello.
Please, sit down. I think you may need to consider getting a letter of recommendation from another professor. Perhaps someone in whose class you earned a better grade.
But, Professor, I thought you'd be the best choice because you know me the best. Besides, I didn't do that much better in my other classes.
Well, you only got a C+ in my class. And on your resume, you're listed as having been in the top 10%, so you must have done significantly better in your other courses.
Oh, did I put 10%? I meant top quarter.
That's a pretty significant mistake.
Well, it's around there anyway.
Around the top quarter? Do you realize how serious this is? You can't misrepresent your class rank on your resume.
Well, I didn't misrepresent it. I exaggerated a little bit. It's not a big deal.
Actually, it's a very big deal. It's dishonest, and it's a violation of the honor code. Have you sent this resume to any other prospective employers?
No. No, I haven't. Okay, all right. I'll change it. Will you still write me the letter?
No. In fact, I need to consider reporting this to the Honor Council.
You must be kidding me. It's not that big a deal. A lot of people exaggerate their qualifications. It's expected. Oh, never mind then. I'll get someone else to write me the stupid letter.
Now a practicing lawyer, Natalie is preparing a brief to submit to the Court of Appeals. A summer law clerk is assisting her by updating the research.
Natalie, can I talk to you about the Smith case? I think we may have a big problem.
Problem? Come in. What kind of problem?
Well, I found a decision by the Pennsylvania Superior Court that I think may be relevant to our case.
Which decision?
Snow versus Storm.
Oh, the court allowed the fiancé to recover, right? That's not a big deal. I read the case, but I dismissed it. The facts are different than ours, so we don't need to discuss it.
Well, it seems very similar to me. The facts are
I've reviewed this case. Look, it's not a big deal. Opposing counsel doesn't cite it in the brief they filed. If they don't think it's relevant, I'm not going to make the argument for them.
Well, I thought that the duty of candor means that we have, like, an obligation to disclose adverse authority, even if the other side fails to disclose it, don't we?
Yes, we have an obligation if it's adverse authority. I decided it wasn't. Would that be all? Look, Snow versus Storm is likely to be appealed. So who's to say the court's ruling will even stand? Is there anything else?
No.
Natalie is now presenting her oral argument before the United States Court of Appeals for the Third Circuit.
I represent Robert.
Counselor, one of the reasons we granted oral argument in this case is because of the intervening decision by the Pennsylvania Superior Court in Snow v. Storm. Are you familiar with that case?
Yes, Your Honor. And yet you didn't cite it in your brief.
Well, Your Honor, I didn't think it was particularly relevant.
Not relevant? How is it not relevant?
Well, it doesn't involve the same fact, and it's also from the Pennsylvania Superior Court.
Wait a minute. Are you telling me that you define what's relevant by whether the precedent case has exactly the same facts as your case?
I believe the facts in Snow are significantly different from our facts. Besides, I read in the legal intelligentsia that Snow is likely to be appealed.
But what does that matter? As it stands right now, it's the only Pennsylvania appellate court decision with reasoning which might help us decide how Pennsylvania law applies here.
Even if you think the facts are significantly different, isn't it your responsibility to demonstrate that difference for the court? Instead, you decided on your own what the court should consider.
Your Honors, I see your concern about the Snow case. If it would please the court, I would like the opportunity to submit a supplemental brief discussing the applicability of the Snow case.
Speaking for myself, I am not interested in hearing anything more from you on this issue.
At this point, I'm not going to grant your request. You made it clear that you knew about the case, but you didn't include it in your brief. You missed your opportunity. Now you should move on.
Okay. At this point, I would like to direct my argument to the damages issue.